All right, excellent. So we are back for voting session and we're still on Senator Carter's amendment package. So, Jamie, could you please read the next amendment in Senator Carter's amendment package?
So we are back on the amendment that is number 143527/1. If you turn to page 15 of the bill, or the reprint, there's a provision that's added by the amendment that says, this subtitle does not limit the authority of a chief to regulate the competent and efficient operation and management of a law enforcement agency by any reasonable means, including transfer and reassignment of a law enforcement officer if the action is not punitive in nature and the chief determines the action to be in the best interest of the internal management of the law enforcement agency. So that's at line 16 of the reprint.
Can I just quick, I don't understand internal management as opposed to management. What's that qualifier? What does that do? I mean, management as opposed to internal management.
So let me take a quick look. I think similar language, if not identical language, is in the current LEOBR. So that may have been just mirroring the language that was already there. But
Senator Kathleen, it could be a matter of just duplicating original awkward wording, but I understand it's like you're saying internal versus external management.
Yeah, that's what I'm thinking.
But I say for the sake of parity, no harm keeping it.
right. So in section 3102 of public safety, current law provides this subtitle does not limit the authority of the chief to regulate the competent and efficient operation and management of the law enforcement agency by any reasonable means, including transfer and reassignment, if that action is not punitive in nature and the chief determines that action to be in the best interest of the internal management of the law enforcement agency. So it's just a duplication of what's there currently.
Okay.
Page 10.
15. Senator Carter, do you have any further discussion? Or Senator Carter, you have a motion?
I have a motion, I move this amendment, I move that we adopt this amendment.
Second.
Discussion, further discussion? Senator Castle, your light's on. I just want to make sure you're.
Oh.
Are you good to go? Okay.
Vice Chair Waldstreicher,
Yes.
Senator Lee,
Yes.
Senator Castle,
Yes.
Senator Huddleman,
Yes.
Senator West,
Yes.
Senator Sidnor,
Yes.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter,
Yes.
Senator Huff,
Yes.
Chairman Smith.
Yes.
That's it?
I think that's all the amendments except the one that we held, correct?
The one that we held, yes. So do you want to go back to that? Which one? We started off on the, when I talked about the board.
We did, minor policy violations was the first one. Then I have subpoena language, in two parts of the reprint.
So if you, can you reread that and then, I know.
It provides if the chief appoints a law enforcement officer to serve as the hearing officer. Oh, I'm sorry. Page 10. And it provides if the chief appoints a law enforcement officer to serve as the hearing officer must be of a rank higher than the rank of the law enforcement officer subject to the disciplinary action.
Yeah, so let's just do this. So Senator Carter, you explained kind of just the amendment and the rationale, and then I know Senator Bailey and Jackson have amendments that are relevant to this portion of this of the statute or of the bill. So Senator Carter, you're up.
So the rationale, thank you, Mr. Chair, the rationale behind this particular amendment, and well, this section and this amendment is that one of the main purposes of this bill is to streamline an internal disciplinary process in a way that is not currently streamlined, and the current system has been ineffective. Not me saying it, multiple sources, reports, Department of Justice with respect to Baltimore City and the like. And so it has also been to put the internal disciplinary processes for law enforcement officers on par with other public employees to a large extent, to eliminate some of these special aspects of their disciplinary process that distinguishes it from others. And so one of those things has been this concept of a trial board, this concept that before there can be any discipline rendered, an officer, an administrative process with respect to his job, has some kind of a right to an adversarial proceeding of some sort by a panel of law enforcement. I felt that this bill, without having a trial board, helps to not only streamline a process, but it also helps to ensure accountability. One of the biggest impediments to accountability and efficiency has been, over the years, many of the chiefs of agencies saying that their hands were tied for various reasons, such as LEOBR, and the fact that trial boards have very often been delayed, put off, and held off for long periods of time while officers remain on the force, often with pay. And so in working on this bill and collaborating with others, including former law enforcement officials, we determined that one of the key aspects to reforming this process is to eliminate the trial board. Other states don't have an LEOBR, and they don't have trial boards before officers can be disciplined. They simply have, they hold the head of the agency accountable, and they still ensure due process, as this bill does. This bill ensures due process because the officer has a right to a hearing. It's just by one hearing officer and not an entire panel of officers. The trial board historically has been one of the biggest areas where we allow police to police themselves, where we say, officers get to have a whole hearing in front of their officers of their same rank and file for a large part. And so, I'm happy to listen to Senator Castley, who's been talking to me, and others, but I would urge us, if we're very serious about police reform and we're really serious about what we're saying, I know some of you may not feel as strongly as I do, that sending a message of repealing Law Enforcement Officer Bill of Rights is what the citizens are crying out for. They're crying out for us to prove that we hold their lives in as much esteem as we hold our law enforcement officers. They're crying out for accountability. They're crying out for a less confusing and complex disciplinary process where that we never seem to get to the truth or never seem to get to justice, and where bad officers, these so-called few bad apples, continue to be on the force. We've heard case after case, like William Green and Anton Black, two of the more recent cases, but it goes back. According to the ACLU report, 500 deaths at the hands of law enforcement officers in Maryland in 20 years. Not only the deaths, but the excessive force, the brutality, the multi-millions of dollars of settlements. To contend that we don't have a problem at the crisis level in Maryland, I think would be disingenuous. And to not be serious about real reform in terms of completely rewriting the Law Enforcement Officer Bill of Rights and some of the ways that it's allowed the bad officers to remain, I think would be doing a disservice to the concept of police reform. We can't say that we're doing serious police reform if we don't do that. So that's my beginning pitch for why we should eliminate trial boards. Other states don't have them. Other public employees don't have them. And due process does not dictate or mandate that an officer have a trial before they can be disciplined or terminated. It drags out the process unnecessarily. It doesn't necessarily bring justice. So I would move my amendment.
Got it. So there's a motion on the floor, but I want to make sure that everyone gets to speak. So I know that Senator Jackson, Senator Bailey, and then Senator Castley.
Procedurally, thank you, Mr. Chairman. Procedurally, I'm not sure where we go next. I have a packet of amendments that addresses one amendment or two that particularly addresses what Senator Carter just spoke to. I'd like to actually offer that and have that put up for discussion. I'm not sure procedurally how we do that.
Okay. Well, let's do this. Let's have a little bit more. There's a motion on the table, so I want to continue the discussion. So Senator Bailey and then Senator Castley and then Senator Huff, let's continue the discussion. We'll come right back to your proposal,
Yes.
talk about it. And does council have your amendment or your proposal?
Yes.
Maybe you could just explain it to us. We'll talk about it in conjunction with Senator Carter's amendment as well. So
Yes. Thank you.
Senator Bailey, then Senator Castley.
So I'd just like to say that, quite frankly, on the record, I do not believe that the entire state of Maryland is reaching out and screaming about police reform. This is not a topic in my district, right? It happens to be where I come from. The person that got the most votes in my entire county was the sheriff, right? He got more than everyone. They are very happy with the way that the police operate, whether it be that of the county police or the state police. The difference is we're in a rural area, but we live by LEOBR, and it is effective and it is working. The standards that we have here in Maryland are much higher than that of police colleagues around the country. It is important that we recognize that. And I think to blanket this, to say we need police reform for the way that the people are being treated by one or two examples, I think is atrocious to the fact that these people are the ones that are willing to give their life every single day for the safety of our citizens. When people at their lowest, they are in terrible need of dialing 911, who do they call? They call the police, and the police come there and help them. That is still, I don't know, I don't live in Baltimore City, but where I come from, when you see a uniformed officer in the grocery store, the children all run up and say hello to them, right? I might live in a different world. But what I'm saying is to blanket them and say that this is what we need because of the atrocities that are going on in this state is just not factual. It is not happening to the degree that is being implied in this by my colleague here. I think that it's very important, and we hear about this all the time since I have joined the legislature, that we need to make sure that people are innocent until proven guilty. The entire concept and the reason for the Law Enforcement Officer Bill of Rights, and quite frankly, I wish they had named it a different title, and we probably wouldn't be here with this today, but the fact is it was to protect officers so that they were all treated the same. This bill was set up so that didn't matter whether you were a minority officer, a protected class officer, or a white officer. You were all treated the same. That was why the Law Enforcement Officer Bill of Rights was put in place. And to just throw that out and say we need, after all the years, 45 years of case law and proven statistics in Maryland that this is working, to just throw it out, we're throwing the baby out with the bathwater. And so I would be very interested in looking at the other amendments. Thank you.
Thank you, Senator Bailey. Senator Kathleen and Senator Huff.
Thank you. So I think, look, thanks. This is a serious issue, and I thank Senator Carter for having the courage to step up and really take it head on. Clearly, there are problems in this state. That being said, I think Senator Bailey's point is appropriate, that it doesn't tend to be statewide. And why is that? I think it's because we keep saying, and I've even heard, Commissioner Harrison said it one day, LEOBR messes up police discipline. People say LEO, but everybody who says that doesn't have LEOBR. They're not, if you look at the jurisdictions that have strict LEOBR, they're happy with what they've got. They're disciplining police. They're getting rid of bad police officers. They're giving due process to encourage the good cops to stay. They're getting rid of bad cops, or they're disciplining the people in between. The challenges that the major jurisdictions have had is not LEOBR, it's that they're not following LEOBR. And I really encourage you, if you take a look at the attachments, what I put in with my bill on LEOBR, read what Governor Schaefer said. Read his warnings that by deviating from the LEOBR uniform standards and allowing jurisdictions to deviate from that through collective bargaining, you're asking for problems. And he even warned, as did the Baltimore Sun, as did MACO and MML, that you're going to undermine the credibility, you're going to lose control, this is not going to end up well. By gosh, it didn't end up well. LEOBR was, by all accounts, was doing very well up until the mid-'80s, when they said we're not going to have LEOBR strict. We're going to have LEOBR can be supplanted by collective bargaining agreements. That's the problems. That's why you have delays. The makeup of the trial boards has changed. The processes are changed. The final decision making's changed. All of that's there. The problem is not LEOBR. It's that they're not following LEOBR. And when we say other jurisdictions don't have it, when I go around and look at other jurisdictions, they have pieces of this. They don't call it LEOBR. I mean, that's sort of irrelevant. That's form over substance. But they do have due process rights. I think it's important that we come up with a system that will treat police officers fairly, that's going to be workable for the next 20, 40, 50 years, that's going to make, as we look forward, we have to recognize that this is a really difficult profession. This is a tough profession. And in professions, we try to protect the people who invested their careers, their lives, their time, their education in building their profession. Lawyers, doctors, judges, nurses, doctors, all these people have basically stand before their peers to say, did you violate our standards? Were your standards up to snuff? That's really valuable. I mean, look, if the cop violated criminal law, they're just going to prosecute him. I mean, the LEOBR isn't here about, did Officer Jones shoot somebody? If he did and it's not warranted, the state attorney's going to come in, investigate it, and they're going to indict the guy or gal. LEOBR is for those lesser things that ultimately lead up. I mean, it's discipline. It's building an atmosphere of discipline. But in building an atmosphere of discipline, that's a two-edged sword. The other half of that is, if you're building a disciplinary atmosphere, there's got to be confidence by the rank and file that this is a fair system. And that's critical, because rank and file people are going to say this system is unfair, and the leader is going to lose control of his people. They're going to be backbiting. The trial board is a heck of a system for maintaining that confidence, because you have a senior person on there who can run it and manage it and make sure it's done by the book. Then you have a junior person who's going to go back and tell his buddies it was fair. I mean, look, we heard all the evidence. I sat through the whole thing. Frank screwed up. I saw it firsthand by myself. Frank can't go back out and say, I got railroaded, all this other crap. One of Frank's buddies is going to be saying, no, Frank screwed up. That's really important to have that level. The other thing is, most of these violations did Officer Jones slit the guy's throat? Most of them are technical things. And the civilians aren't going to understand. These are technical violations that indicate maybe a problem officer that are going to build up. Having civilians in there is good for oversight, but in the end, the profession is going to have to police itself. And the chief is going to have to be responsible for that, for maintaining that level of discipline. The counties that follow LEOBR, the chiefs are responsible, the sheriffs are responsible, people look to them, they deal with the minority community, because they know darn well, if somebody's mistreating a minority community, buck stops right on their chest. No, there's nobody to say, he can't push it off on the union, she can't sidestep the allegations, and they know it comes right to them. So this is a really good system if you have that, and I really encourage you to look at what Governor Schaefer told us was going to happen, because you know what? It happened, and we're in a bad position, and people have lost faith in the system, have lost faith in policing, just as he predicted, just as the Baltimore Sun predicted, just as Mako and ML predicted, just as the Baltimore City government predicted, just as I think Hagerstown predicted it. There's a whole bunch of them who said what we're saying is going to happen. It took a little bit longer to reach boiling point and smack us in the face than you might have thought. But over time, clearly it was a cancer that was planted. It eroded confidence, and now we're all stuck with dealing with that. But we've got to put a system in here that's going to actually last and make a lot of sense. Thank you.
Thank you, Senator Cassidy. All right. We're going to go on to Senator Huff and then Senator West, and then back to Senator Jackson, unless anyone else has. Senator Sidner after that. Okay.
Yeah, I was just going to say, I think on this we're trying to balance the chief's ability to discipline and deal with bad officers versus due process. And so I think I'd like to find a compromise on this, an agreement where we can come together and we could, if the system's out of balance, those argue the chief isn't able to discipline enough, how we can rebalance. But the problem with this is that it goes way too far, in my opinion, in the other direction. I mean, this is completely to the side of the chief and completely away from where we're at now. And if anything, maybe we need to step back some, but no, this just goes completely away from that, in that this gives all the power to the chief. So the chief they appoint this person, it's their person, they're going to enact discipline. And so that's why I don't support this. I'd like to look at some of the other options. I think this one is just too far. It's a bit draconian in my opinion. I will say though that just some of the remarks people listening about their districts. I mean, I think it's important that we remember though that I think actually what Senator Carter said is very insightful to know what other people's districts, what their thoughts are, because at the end of the day, and Mike Miller used to remind us, we are state senators. So we have our role, it's our district, but then we have to remember what is the good for the whole state. And we all represent our constituents, and to try to list to others what their constituents are saying. And the last point I'll bring up, that I'm still sympathetic to the trial board, and the idea, and I was talking to Charles about this beforehand, just my personal experience being an enlisted guy, it's much different than when you're an officer. Actually, it's a great experience because when you go in the military right after high school and you're enlisted, you as far as making friends, race, it doesn't matter, all that stuff, because you're all the same in that you're all the same class. None of you came out of college. None of you had rich backgrounds. You're all in there together. And the guys that aren't together are the officers. They're above you. They all went to academies. They went to college. So when we had if you got in trouble, their version of a hearing board, you always got at least one enlisted guy on there. You got two officers and one enlisted guy on there. Because enlisted guys were more like the blue collar, and the officers were like the white collar. So at least there was one guy that was at least of your rank, knew what your life was like, and knew what was going on, add a little bit more fairness. So I guess that's my sympathetic part to at least trying to keep the trial board and look at some of the other options. I think this one is just a little bit, this option is just too heavily skewed towards the chief.
Senator West and Senator Sidnor.
Thank you, Mr. Chair. I agree heartily with what Mr. Huff just said. I've gone through this thing, and my understanding was that the reason we got Leo Bohr Law Enforcement Officers Bill of Rights in the first place decades ago was because the chiefs ran the whole show, and the police felt as if the chiefs with no due process at all could just lower the boom on them. So the reaction to that was this bill the statute we're now dealing with. And they may have gone too far the other way, but this takes us all the way back to where we were back then. So I've gone through the bill. Page 7, the chief designates the investigator. Also on page 7, after the investigation, the chief determines the discipline. On page 8, the chief gives the opportunity for a meeting. On page 9, the chief or his designee meets with the officer. On page 9, after the meeting, the chief imposes the discipline. On page 10, the chief determines whether a hearing is necessary to resolve disputed facts. Also on page 10, the chief appoints the person to preside over the hearing. So it's the chief's subordinate who presides over the hearing. On page 12, the hearing officer appointed by the chief provides written findings of fact to the chief. Also on page 12, the chief determines the discipline. I mean, all the way through this, it's the chief. The chief is the prosecutor. The chief is the judge. The chief controls every element of the process. This goes far too far the other direction. We need something that's going to be in between. And I think there's some other bills that try to provide some balance that we should take a look at.
So it's going to get Senator Sidnor, then we'll come back to Senator Carter, then we're going to end up with Senator Jackson.
Thank you. I just wanted, as I was listening to a number of the comments, I just wanted to push back just a little bit on, and I appreciate Senator Huff for making the comment. We are state senators. I just took a look at it's the 2019 report for the report of the state of Maryland's deaths involving law enforcement officers. And as I counted, the majority of our counties have had some civilian deaths, not a minority, but the majority. This report goes from 2015 up to 2019. 33 law enforcement agencies had some sort of civilian involved shooting or death. So this is not necessarily just a Baltimore City or Prince George's County or Montgomery County issue. This is a statewide issue. While this report doesn't necessarily say what kind of administrative hearings were offered or whether or not something like that happened, I still think this is the canary in the tunnel that says that there is an issue that's happening statewide that we do need to deal with. Now, with that said, when I travel, I live in Catonsville, but I work in Howard County. My parents live in Baltimore City. I come down to Anne Arundel County for work. I would like to think that whatever happens to me, however I'm treated by a law enforcement officer, regardless of where I am, I'm going to have that same level of courtesy given by the officers, and if there's any type of discourtesy or anything that goes beyond what should be, that officer would be given that same type of discipline. And I think what Senator Carter's bill is doing is it's pushing us in that right direction. I believe it was just 2 or 3 years ago, I wrote an op-ed about an incident that happened to me when I went with my family down to Virginia and was stopped because I was driving in the right lane for going too slow. This is what the officer told me as he dressed me down in front of my wife and my 3 daughters. Messed up my trip for the first few days because then I'm trying to figure out, well, how do I file a complaint against this officer for trying to make me look like some sort of child? These incidents are real. When I was in law school, I remember traveling from a friend's house in downtown Baltimore to go home, and I lived in probably a few blocks away from where Senator Carter now lives in southwestern Baltimore City. I had an officer stop me, well, this is what he told me after he had me waiting for, I would say probably about 20-some minutes, that he stopped me because I went through a yellow light. Now, you tell me where that's a problem. I went through a yellow light and he stopped me. I knew what that was about. I know exactly what it was about. So it's with those kinds of incidents that I believe a lot of the advocates, they're pushing for this reform, that I think is exactly why Senator Carter is speaking so passionately about it. Yes, I hear you. I believe there should be due process and people should be treated fairly and the like. But again, I think the incidents that have happened have shown us that there is some sort of a cancer that exists and that this system, the way it has been played out, is not fair. And with that, I'll rest. Thank you.
Excellent. Thank you, Senator Sidnor. We'll now turn it up to Senator Carter, and then we'll end up with Senator Jackson. Did you still want to speak?
Thank you, Mr. Chair. Yeah, just briefly, I just wanted to point out a couple of things, primarily with Senator West. I get it that that's the way the bill reads, but I want to just put out there that currently with the way agencies operate, first of all, the commissioner or the chief or whatever that person is called, the head of the agency, that really is their job to be the manager of the agency. But they currently appoint those people that are the investigators that are in their investigation, in their internal affairs divisions or internal investigations divisions, or the detectives that do the investigations, like the chief appoints them or puts them in those positions. So this isn't that crazy that like the chief determines the investigator, because they already do, and they also already determine who's on the trial board. So to a large extent, the chiefs already control, but the issue is when there's a trial board that then takes the situation out of the managing control of the chief and puts officers that are the peers of other officers there to make determinations. That is what has been very much an impediment and a bottleneck to streamlining the disciplinary process. So I just want to say that I've said before, so I don't want to sound like a broken record or anything, but we are very comfortable with this idea of trial boards because we have them. But many places function just fine without them. And, you know, prior to coming back here to the Senate for a brief time, I was the head of an agency, a civil rights agency, and it was painful for me because I'm like a bleeding heart, but I had to terminate some people while I was there because of, you know, disciplinary issues. And to me, I just want to illustrate this. So, employee in my agency violates a rule. We have a meeting. I decide to terminate. They then were able to appeal and have another, like a civil service type hearing, and then it was done. But what we do now with the trial board will be akin to me having 3 other employees in the agency sit and determine whether or not the very employee that violated the rules should have her, we should be able to terminate them. It's like, and I can't even imagine like picking 3 other similarly situated employees and say, hey, determine whether or not this person that you work with every day and you go to lunch with every day and who you give Christmas gifts to and go to dinner and, you know, have family outings together, I need you to make a decision whether or not that person should go. That's what we really do with law enforcement officers now, and it is unprecedented outside of LEOBR. I won't go on, but this isn't like outrageous because the chiefs largely have control now, with, except for that one area that the FOP want to keep. They want to keep that ability to have officers police themselves, which is really what they have. And I feel like that's the impetus behind all of this. We got to keep the trial boards at any cost. So, I mean, we have tried it for a long time with trial boards. I'm not going to go like, you know, tit for tat, but I don't agree that the system has worked well or that it's working. Maybe some jurisdictions are better than others, but certainly almost every jurisdiction here of people that we represent here has been impacted in some way by policing that has, and disciplinary process that hasn't worked well for the people. And that's what we're here to do. Fix it.
All right, so I want to do, since you guys have the sidebar, all right, Senator Bailey, and then we're going to go to Senator Jackson. This has been good. So,
Just real quick, and just Senator, just a matter of clarification. And I have not been in a trial board in Baltimore City, but with the state system and the way we work locally, when we have a trial board, the chief does not pick the officers. The chief contacts people of his other sheriffs in his area, other departments, and they say, we've got a trial board. And they send officers that the chief doesn't even know, right? It's not, these are not the chief's, flunkies that come over there to sit on the trial board, so that's the way it works. And it's not, they're not picked by the union. It is not just a situation that police officers get to pick who's on the trial board. So, right.
It's different in different jurisdictions.
Right. I was going to say that is clearly not the case.
okay, excellent. So it looks, this is the first, amendment we've discussed for consideration that's had a considerable amount of debate. And so what we're going to do is open it up. It's Senator Jackson, hear your proposal on point, and we'll go from there.
Thank you, Mr. Chairman, and some great points around the room from everyone. I understand the concern that Senator Carter has. Just like to speak briefly, very briefly, before I talk about the amendment I'll propose. I've had the opportunity to engage every agency in the state of Maryland in one of my capacities. The one thing that I do know is that every agency doesn't operate the same. So I guess the goal here is how do we get to some sort of, how do we get to the point where we begin to rebuild that trust, a trust that I knew personally how hard it took to gain, and how hard it is to maintain. How do we get to that? But we have to have a balance. I have an issue with allowing a chief or sheriff, as proposed in this bill, to to act in this capacity. And I'll say that, and that, it may sound a little funny coming from a guy who was a sheriff, you know. However, I was also a troop, and I was also a union guy, the union president, and then I became the sheriff. So I have lived through every facet of this in a county of almost 1 million people. So I think I'd like to say that LEOBR and collective bargaining are not, some agencies have collective bargaining, some agencies do not have collective bargaining. And I think that there are the actual understanding of what LEOBR is known by some and not by others. So this is not going to be a teachable moment, but what I'll say is this. I think that we need to maintain a board because that offers a sense of balance in ensuring that accountability is there. The board is set by the chief or sheriff. The board there's a board commander within an agency. That's that person's job. That's a trial board commander, chairperson. And I'd like to, Jameson, if you could, I think if you could read through that section of my amendment, I guess that would be the best way to do it, and then we can go that route versus, I think there's been enough said around the room. I think we all know that we need to do something regarding. I am not against police reform. I think that we need to come get to the point where we bring something out of this committee, particularly on this point, that makes some sense and brings some balance. And I have some ideas. So if you could, Jameson, if you could.
Which section of the amendment are you referring to?
It's going to be under Amendment 2. It's going to be on page, I'm sorry, it's Amendment 4786761. It's going to be page 4. Sorry, page 4. And on page 10, line 4.
Page 10, line 4. Okay.
Yeah, it's like halfway down where you talk about.
Let's see.
If you drop down to, I think it says point in line 16 down through second hearing in line 18, substitute. It begins.
Senator, I might need just a minute. It looks like my copy is a little cut off.
He's looking through the computer system. It's processing, so he's trying to pull it up.
But look, I can pretty much summarize this. I think we need a board. I think what we need to do is to come up with the configuration of a board. I think that if we give a chief or sheriff the absolute control of a disciplinary process. I got elected sheriff in 2002, and we went to Colorado to the National Sheriff's Institute for, baby sheriffs. And one of the first things that was mentioned to us by the instructors there was, be very careful, ladies and gentlemen, never to fall into the trap of becoming a Lord High Sheriff, where everything falls on you. You are the one who dictates it, you are the one who carries it out, and then you are the one who renders the discipline, because you're not going to be the one that's going to be able to hold that. So we need to be very careful not to do that, and I really don't think that that's what the chiefs and sheriffs would like. I've had that conversation with them. Accountability, I think, has many faces. It starts with, obviously, with the agency head, but it's also up to that rank and file officer to make sure they're doing what they're supposed to do. And I think the disciplinary process with a board that allows a structured process to bring about the facts, made up of a mixture, if I might, of sworn and civilian. 2016, we authorized civilians to sit on boards. Now, I'll say that maybe the notification process from the executives of these agencies wasn't up to par, and civilians didn't know that they could participate. The Maryland Training and Standards Commission, which we created, is equipped to train the civilians who would sit on these boards. But I think this conversation is occurring at the right time, and I think we're ripe to, I think there are some folks who talk about the reimagining policing. Well, I think transparency is key to that, and that transparency comes about with us making sure that, one, there's due process for the folks who are performing the duties that we expect and believe, and secondly, that it's an inclusive process. And I don't know why we don't have these.
Excellent, thanks. He's trying to track them down now, but
So Senator Carter, I would like to ask, I don't know if, again, procedurally, I don't know if we need to vote on Senator Carter's amendment or if I can offer.
so what's happened is, so there's been a motion, it has not been seconded, and then so the discussion is open right now. So then the next thing would be to just, yeah, we can make sure you guys get copies.
So if I might, well, I guess, what do we have to get to, a second or in order for?
No. So what we would do is we could keep here, we could keep this open for discussion.
Okay.
So, and we can
All right,
talk about, we want to hear the actual, the actual language of your
Gotcha.
amendment.
So I'll keep talking about it. So typically,
And then
what
I have a couple
occurs-
questions too. Yeah.
Typically, what occurs is the sheriff or the chief assigns a commanding officer who oversees all administrative boards. So that's the relationship, other than the sheriff or the chief having to do that themselves. That's what that person's job is. That person's job is to be the discipline officer and accountability officer within the agency. From that, in most agencies, and I think in the original LEOBR, you have a five-member board. That's typically how it is. And in Senator Carter's bill, she's asking that we get rid of the board and we have just the chief or the sheriff. I'd really like to seek a compromise in that. I think if the way it's written today, if that's not satisfying to the sponsor of the bill, I'd like to make a compromise. I'd like to say we do a 2-1 board, a 3-member board, where you still have a commanding officer that's going to ensure that the processes and the procedures are adhered to throughout the entire proceedings, and that the civilian members are trained up through the Maryland Police Training and Standards Commission, and that those findings are final. I think I'd like to offer that to the maker of the bill.
All right, who's on? Is it Senator Lee comment, and then council will chime in with the language.
Yes.
Would it still be the 5? It would be a 5-member? Is that
Actually, Senator Lee, I think because
or a 3-member?
I'm actually now proposing 3. My original was 5. I think Senator Carter comes in with no board, no administrative board, and the sheriff or chief. I was coming in originally with the 5-member board, but I am willing to offer a 3-member board.
But of that 3-member, at least one would be the chief or the head of the agency?
No, ma'am. No, ma'am. The chief is not a party to the board. There would be an officer assigned to the board.
So who would be part of the 3-member then?
Look at the chairman here.
Senator Jackson, just for clarity, so it'd be a three-member board appointed by the chief or the head of the agency, is that correct? Who would be composed of the 3 then? Or are there conditions for the 3? Who would they be?
Who would be? I couldn't hear you.
Who would be the 3 members?
The 3 members on the board?
Yeah.
3 members of the board would be, I propose 2 civilians trained up and a law enforcement officer. And but also understand that there's always a commanding officer that oversees the entire process. So that person is not actually sitting there in, lack of a better word, judgment for that day. But there's 2 civilians and 1 sworn officer that sit on the board that hear the facts, weigh the facts, render a decision.
Been part of the investigation, or
No,
yes
ma'am.
or no?
None of them are part of the investigation.
I think Senator Carter's concern was that they're not, that the police officers are not, doing their own investigation of their own people at the same equal.
Absolutely.
That's the concern, that, that they're just not policing themselves. Would this address that, though?
Actually, it would. So I would call, yes, ma'am, as I've done many times, unfortunately, I would call my colleague in the sheriff's office somewhere in the state, or I would call the chief and say, hey, look, we have a trial board, and I need for you to send me over 2 or 3 law enforcement officers to sit on this board. So never is there a member that's that's a party to an incident in the agency.
Did you want at least one to be of equal rank to the person who's the subject of the investigation?
Yes,
Or
ma'am.
not?
Well, it could be. I mean, that's a negotiable item. I mean,
I'm not saying that that's what I want. I'm just saying, is that what you're asking for?
got you. Yes. I mean, you want someone who that officer has to be someone who has actually experienced law enforcement. So you really do want someone. If we're talking about a fair process, you want someone. So a jury is composed of your peers. That's quote unquote. And this would be the same. So you'd have 2 civilians, and you would have a law enforcement officer who has actually, done the law enforcement work. So,
Okay, all right.
not a commander.
Okay.
Okay, excellent. So, all right, Senator Leader, any more questions?
Hear from Senator Carter, too, as a response to that proposal, I mean. It's-
Thank you, Senator Lee and Chairman Smith. So my thought still is that we seem to be unable or unwilling to accept that the head of an agency should actually be able to manage the employees in that agency's workplace, and that we are very wedded to this ideal that we've had for a long time, that there can be no discipline given by an agency without a jury of the peers. This is not a criminal proceeding. This is administrative, and other administrative processes in other states and in this state for other public employees don't give people a jury of their peers before they're disciplined. This is about, did you do what you were supposed to do on your job? Did you violate the rules of this workplace? Did you violate our policies? You don't need a jury for that, So, I mean,
I would
I
counter.
will also say, so my first thing is I still contend that we don't need to have the whole trial board. But my second thing is I absolutely, of your proposal, I disagree that if we were to have one, that their decision would be binding. I think they should be in the position of hearing disputed facts and then making a recommendation of discipline, but I still ultimately think the discipline ought to come from the head of the agency, not the trial board. They shouldn't be the final decider. That's a lot of why we have not had accountability.
I got you. So may I respond?
Yes.
So I want to respond first regarding the jury jury configuration, or so even though we are talking about an administrative hearing, let's remember that even out of a criminal incident, there's also an administrative hearing that follows that incident. Because whatever happened out there on the street, guess what? That sheriff or chief should be holding me accountable for that incident on the street. Now, if the prosecutor is trying me for a crime, then somewhere along the line, if I'm going to be tried for a crime, I probably violated some policies within that agency. So the reason that it's vital to have a board is because as a sheriff, even as a troop, but as a sheriff, I need to know, or chief, I need to know that my policies policies and procedures are applicable to tomorrow or, today. Today is already over, but are applicable. And I can't ever find that out unless I have, a board setting where we can get the get the finding of facts so that we can then assess how we move forward in our agency to keep it professional. So that's part of the reason for a board. But you also have someone there who could also lend that experience of being someone out there, doing maybe a like incident, maybe not a like incident, but has some experience on the job. And we can actually, we can debate the findings and whether that's final or not. Some agencies, again, across this state, the sheriff or the chief can come in and say, I don't like what the board says, this is what I want to do. In some areas, they don't have that ability, so.
All right, so you go to Senator Huff and then Senator Castley.
Just real briefly, so we can, I know we do have somewhat of a time limit, just to move things along. I mean, we can just get in circular discussions. We should actually start working off something. And so, I'd like to make a motion on Senator Jackson's amendment, a favorable on it, so that we have something we can start working off of. Otherwise, we're just going to have philosophical discussions, which would be fun and all, but I'd like to actually...
No, actually,
So I make a motion favorable on his amendment, and then once we make the motion, we can get into the amendment and make changes and discuss all these different provisions.
So we can't.
hold on a second. Just to be clear, this was a good conversation that's going on. Literally, as soon as Senator Jackson finished explaining the kind of the context of his amendment, council was going to explain exactly what it was, and then a motion could be made. So,
Well, look, with all due respect to, I love Jamie's reading of these long readings of them. I've read, while everyone else was talking, I've read the amendment. I'm making a motion on a favorable, and then if there's a second, then we can just start working off of it, or read through it or something. But I don't want to read through an amendment we're not even going to pick up. 'Cause that's going to be
we are going to consider the amendment, and it will be read. But so there is a motion before, but I'm going to ask you, as we always do, we got to read the amendment before we can make a motion and understand what we're actually doing. We've had an explanation and concept. We want to read the amendment so we know exactly what we're motioning on. So Senator Castley and then Senator Sidnor, and then let's get to this. Let's get to it. I do agree we do need to start working on it.
I just want to make I had to correct something because there's been the suggestion that this would treat police officers like everybody else in the state system. And I just want to really quick, because I'm sitting here with a state government article and the state personnel article, and what would happen for a professional? Cops are professional. What would happen to a professional who's not a cop in the state system, who would then go to their director, their supervisor, whatever it is? They would administer a discipline. They would say what it was. Then you could appeal to the agency head. The agency head could review it, check it, do anything they want. Then you can appeal to the Office of Administrative Hearings. If you do that, you have a trial. Now you go through a whole trial before the OAH. Now the Office of Administrative Hearings can override the secretary. They can say, no, we're putting them back into place. So, there's a lot of roadblocks there that protect these professional employees who aren't cops. In fact, the Office of Administrative Hearings can actually do what we exactly don't want. They can undermine, if we did the same process here that we're doing for the rest of the state and professional employees, this would totally undermine what Senator Carter and I both think is important, is to hold the top cop responsible. Because the top cop could then be overridden by the Office of Administrative Hearings. So, as we're trying, so you don't get to go to the Office of Administrative Hearings, which makes it even more important that you have a fair process, because you don't get to go there. So the cop needs to feel fairly treated. And I think that's important to balance this out. These are professionals who have lots of time invested in this. We got to have a system that protects that. But if we're gonna go tit for tat here on what do the other professionals in the rest of the state government have, they got a lot of protections here, including that one last thing to let the Office of Administrative Hearings give them a trial and override the secretary completely. So I just think that puts us more puts more emphasis on having some protections for these cops within this process, and so that's important.
All right, last comment before you go back to the actual amendment, Senator Sidnor.
I just wanted, I know Senator Huff was trying to make a motion, but I thought that there was already still one that was open.
That's
and I
right.
just wanted- That's all.
Okay. All right, so you've got a motion that's open on Senator Carter's initial amendment. We've had to open.
It was a little amendment, by the way. It was a teeny little amendment. It just, we got into the discussion about the trial board because the next step was just
Yeah.
the step of the hearing officer.
So it has not been seconded.
Wait a second.
She had a motion first. It never,
You announced that it had not been seconded.
and it's not. So now we're moving to your,
Yeah, then I motion is seconded.
so hold on. So let us read the amendment first and understand what we're voting on. Go ahead.
Man, I lost my place.
Amendment's a little bit lengthier, but to the part that Senator Jackson had asked me to read, if you turn to page 10 of the reprint, starting at line 11, this is the makeup of the hearing board. So it strikes provisions of the bill as it's drafted and instead provides if the law enforcement officer requests a hearing in relation to the disciplinary action, the chief shall order a hearing to make findings of fact and recommend the discipline, if any, to be imposed by the chief in the matter. So the chief shall appoint a hearing board of 5 individuals that would consist of 3 individuals who are sworn law enforcement officers, one of whom would need to be equal rank to the law enforcement officer who's the subject of the disciplinary proceeding. Then there's 2 options. If authorized by local law or ordinance, it could be 2 individuals who are members of the public who've received training from MPTSC, or if no local law or ordinance has authorized the appointment of members of the public, 2 individuals who are sworn law enforcement officers. 1 member should be appointed as the chair, and all would have equal vote in the matters before the hearing board.
So Senator Jackson, so I'll let you go. So Senator, there is a motion that's been seconded, so we will entertain it. But I would like, I almost have some suggested changes to the amendment, which you can't make at this moment because it's been seconded. It's over before us. So I am going to vote against this amendment because it's just the way it's drafted, and I think we should talk about some additional changes to what the framework you've laid out. So I'm just explaining my vote, but I'm going to Senator West and then Sid.
I got to play you three, too, because I don't understand. The last time you motioned and seconded, we went through it line by line and then, worked on the amendment.
So he proposed this piece of the amendment, which is a lengthy amendment, but he proposed this piece. Remember last time for Jill's, we just went through portion by portion?
There was a motion and a second. I thought we went through amendment line by line and did it. I'm just trying to get us to work off of this amendment.
Yeah. I know. I feel like I don't want to adopt this version of the amendment because there's some changes.
I wasn't trying to do that. I'm just trying to get us to work off this amendment is what I'm trying to get us to do.
So but if you adopt it, it's going to go onto the bill.
Yeah, we have to discuss, we can't.
So we can discuss the amendment now. We can work right off of this. You want to do that?
I want to go through this amendment, and start voting on it and start moving this thing.
Okay, well, let's do that. So then,
all right, I'll withdraw my motion on the favorable on it, and I want to start working off this amendment.
absolutely, that's great. Then we don't have to do it the reverse way I was thinking. Senator West, you have a question?
I was going to propose.
Okay, great. That's fantastic. So now let's dive into this piece of the amendment, which is on page 9 of 17, and we'll just go through it line by line.
It's page 10 that we were looking at, Mr. Chair. Right, so that's just where the language is, ran over the line. So we're on page 10, and right, it's as I described it with, the chief would appoint the board in the event that the law enforcement officer requested the hearing, and it would compose of 5 members, although Senator Jackson had noted 3-member board.
So could we, so 3-member board, line 18.
So in line 18, this is, the chief shall appoint a hearing board of 5 individuals who had no part in the investigation of the law enforcement officer who's the subject of the disciplinary proceeding to preside over a hearing held under this section as follows. 3 individuals who are sworn, including 1 individual who's of equal rank to the law enforcement officer who's the subject of the disciplinary proceeding. 2, if authorized by local law or ordinance, 2 individuals who are members of the public who have received training administered by the Maryland Police Training and Standards Commission on police discipline and police procedures, or if a local law or ordinance has not authorized the appointment of members of the public to a hearing board under this section, 2 individuals who are sworn law enforcement officers. So it could either be a board of 5 law enforcement officers or a split 2 to 3.
So just entertaining your proposal, you wanted 3 people, 2 civilians, 1 law enforcement officer.
If yes, and as the language states that if those folks weren't available, then obviously it would be 2. Because you don't want to delay the process. But
That's, the 3 is better than the 5, absolutely. And I agree with the idea of having the 2 to 1 split. I mean, it's, to the extent that I agree at all, but.
Understood. But,
To the extent.
But just you know, the chief or the sheriff is the one who's still in control of this body. This is just the makeup of it, and then it's also up to the chief or sheriff, or there's another amendment I have later to make sure that from a regulatory standpoint, that these folks are trained and prepared to be ready to sit on these boards. So.
Or if we have 3, is it 2 policemen and 1 civilian, or 2 civilians and 1 policeman?
But there's always a commander that oversees the board, so that person makes sure that everything is adhered to. So the sheriff or the chief has a commander. It could be a captain, could be a major, who is who oversees all disciplinary boards. And
Well, the amendment I have in front of me says the chief shall appoint 1 member of the board as the chair, so it would mean the chief could appoint 1 of the civilians as the chair.
yeah, that's for the board members. Yes, absolutely.
Where does the commander come in? I didn't understand that.
The commander, well, the chief or sheriff typically has, and I come from a larger agency, they typically have someone who's in charge of discipline for the agency. And that's the person who oversees all boards.
Where's that in here? I just can't find it.
I don't think it's in there.
Where's language about someone?
He's proposing that language right now.
Yeah,
Oh.
that's something we can write in, because it's not consistent with all, if you look it up, all agencies don't have that. So that's a part of it as well.
I'm sorry, I'm still confused. So we got a 3-person board, we have 2
Yes.
civilians and 1 policeman, and then you've got this commander who's not on the board, but somehow he, oversees the board? And what does he
Oversees the
do-
board.
What does he do to oversee the board?
Oversees to make sure that the processes are adhered to in that board, that trial board or that administrative proceeding is carried out according to the
So he's
code.
sort of like a judge?
Yeah.
A judge
It's just sort of, yeah.
that runs the proceedings, but then if the commander does that, then what is the member of the hearing board who's the chair of the board do?
The chair, so I guess, let me step back a second. in my agency and some larger agencies, you have a person that's that oversees the discipline and those procedures within an agency. That person doesn't necessarily run it. That person makes sure that it's set up, that everything is established and everything is running the way it needs to be. So, but the board makeup I'm proposing is 2 civilians and 1 law enforcement officer. Should the civilians not be trained up in time or make themselves available, then obviously it will revert as the language in the bill states, that then it will revert to 2 other officers.
Okay.
Let's go to Senator Bailey, unless Senator West, you're done.
I'll have to look at the final language that Jamie drafts. I'm sure.
Okay.
Jamie, did you catch that?
I think I'm going to need to review that again or sit down with Senator Jackson. It's up to the committee.
All right, we're going to go Senator Bailey and then Senator Carter.
So, okay, just because Senator Jackson and I have sat in these positions, I just want everybody to understand that officers right now, if they have a hearing board, they have 5 officers, or what the General Assembly did back in 2016 was they allowed 2 of those people to be civilians. Okay, but that was only if those people were trained. If not, it still went back to 5. And so it was a process that was in place. And to go from 5 to 0 is extremely radical. And I do appreciate the fact that we are discussing this. What I would, to me, in my mind, as we make progress, it's always important that you crawl before you walk, and we look at things. But it would make sense to me to have 1 person, just as we talked about, as the hearing officer that's of higher rank, that runs the hearing. You have 2 officers that are on the board, 2 sworn officers. We can say they can be outside agencies, whatever. 2 civilians. If there's a tie, then the hearing officers who's a higher rank, that person weighs in. But that gives some ability. I think it's completely fair, and it's not anything that is taken away from the process. And we can even mandate that there has to be 2 civilians on there. But I think that to me, I just think that's a equitable system.
So Senator Hedelman.
Thank you, Mr. Chairman. I have a question, and Senator Bailey just said we can mandate that civilians serve, but here it says, Section 2(1), that if authorized by a local law or ordinance. So are we going to rely on the participation of the civilians to the local ordinance? I don't know. Senator Jackson, is that what? Because I wouldn't, then that creates a system.
No. I would say you want uniformity, so you remove it. But
I would agree. I was going to say that too. That was going to be my question, so yes.
That's problematic if we don't mandate it.
yes, but just
I think that's the point of this, to have the uniformity.
Correct. So let's just Senator Jackson, go ahead. But let's go ahead and
With that.
keep on point. Okay, great. So then you've got 2 people. Your amendment to your amendment is 2 civilians, 1 law enforcement officer, and of equal or higher rank. So that's before us. Let's just do line by line and vote on that change.
First one, so you got Roman numeral 1. 1 individual, sworn law enforcement officer, who is equal or higher rank to the law enforcement officer who's subject to disciplinary proceeding.
Correct.
That would be the proposed change to it.
We leave 2 as it was, which is if the local law authorizes.
No,
it.
you're gonna.
No?
We're striking that.
Don't go down there yet.
Let's just go
Just do
one
one
line
at a
at a time. Yeah.
All right.
All right, so Jamie, can you just parrot it back?
The new language reads, disciplinary proceeding to preside over the hearing held under this section as follows. One individual who is a sworn law enforcement officer who is of equal or higher rank to the law enforcement officer who is the subject of the disciplinary proceeding.
Got it. Senator Carter.
Senator Jackson, in my original proposal, I had proposed that the officer, when it would be one hearing officer, be of higher rank, because I thought they would be in a better position to, make the determination. So I wanted to know why you feel strongly. You say either or, so would you be okay with having an officer of higher rank? What's the efficacy of having either or?
Thank you for the question. Again, so under collective bargaining units or rank and file members, those rank and file members can be, you could have a person anywhere from a private up through a lieutenant. It depends on the type of the organization that you have. So you could have an officer who is in patrol. The higher ranking person can actually, I mean, look, I can, if you're good with that, I can do that.
Let's do higher rank.
Got you.
Senator Bailey.
So
Can we get Senator Bailey?
the whole issue is walking in that person's shoes. If you were to say a higher rank, if you were in a state agency to become a corporal, to be a higher rank than an officer, there's 3 years mandatory experience. To become a sergeant, you might need another 3 years, so it'd be 6 years on. So if you were to say, okay, he's got to be higher rank, that person that would be there would have been there 3 or 6 more years than the officer that was being judged. And you want to look at things from the training and experience level of the officer that is being charged. I think it is important that that person be of equal rank. If you want a person of higher rank, I think that's fine. But I think that I would go back to the suggestion that I just had a minute ago. Have 2 members, have 2 law enforcement officers, one of equal rank. That, because it is, you learn a significant amount when you are a year on the job, right? You learn a lot. But when you've been on 5 to 10 years, you know an encyclopedia, right? You have seen all these different incidences. So I think one of same rank and then one of higher rank, that gives you 2, and then 2 civilians.
So the only problem,
So you got a 4, and then if there's a tie, the person that's higher ranked.
I like keeping it leaner because, I mean, as has been pointed out to someone before, is that just in terms of the timing and speed and availability of folks, I mean, once you start expanding the number, you start getting into hard to track people down and get them to participate. So it just becomes a logistical hurdle as well.
So I'd also like to point out that when we're talking about with this, we're talking about administrative.
I know.
When we talk about the fact of an officer committed a crime, right, a criminal violation, we already have the grand jury, right? We have a whole bunch of civilians that are sitting in that room that indict that officer on that situation. What we are talking about here is an administrative violation that officer did. And I think it is imperative that you have somebody of the equal rank that walked in your shoes. Those of you that are in the military clearly understand that. The fact is, because you have the experience. When you take somebody that is sometimes the most knowledgeable person in a police department is a 20-year officer. That officer has seen everything, right? But that person, the one officer to an officer, that person sits on the board. Then you have another one of a higher rank. However, we make it so that you get to the third, so an odd number, I'm fine with. But I think it's important that you have one officer of the same rank.
I like the equal to or higher, and I like the smaller number, but I do have a question, just, so if you are a high-ranking officer, let's say highest to, like, right below the political appointee level, like the chief, how do you get something that's higher to that, apart from being the sheriff or the chief, if you're, at that highest level? So then, no. So I understand that. So the chief serves at the pleasure. I get that. That's
Well, I think
a
the
different
senior-
process. But I'm saying, what if you were right below the chief?
I thought they served at pleasure of too. I thought your top, ask these guys, they know it.
It depends. So some agencies, you have the sheriff or the chief, then you have lieutenant colonels, lieutenant colonels, majors that rank, right? Could be captain, it depends on the size of the agency, or it could be lieutenant. That's, my original proposal says equal to or above. So, and I think that's sort of the rationale for that. And again, but I also understand what Senator Bailey is saying as well, because you have to be careful not to have, a captain and you got a slick sleeve that's sitting on there. So, equal to or above, we can go back to that. I mean, hopefully, Senator Carter.
Wouldn't be higher rank.
Officers, I know there's some people, I guess, that skirt the normal process, but everybody that would be in a higher rank would already understand what the job and the responsibilities are of the lower ranking officer, right? Like, they would understand that. They would have once walked in those shoes, correct?
We would think, yes. Yes, they should.
Isn't that like saying that beat is the same as it was 30 years ago when you walked it? And I walked that beat in McDonald's back in 1980. What's your problem? Well, it's not the same. It's 2020. It's a little bit different now.
Senator Carter, if I might, so if we leave the option of equal to or above, that goes to the chief, that goes to the sheriff, right? So it's giving them that accountability. They make that decision. That's a decision they have to live with after the findings come out. So.
All right, so let's.
Equal to or
So
above.
right now, all right, let's put this up. We'll put it before the committee. So higher is so you've got. So we'll just put of higher rank. Let's vote on that. And see what folks think. What?
Move favorable.
So it's,
What's that?
we've seconded on, so just to be clear what folks are voting on, we're voting on the three members. Can you just recite again?
Right, so the amendment would be for 3 members. One of the members is sworn law enforcement, and who is of higher rank than the law enforcement officer who's the subject of the disciplinary proceeding. And we haven't yet gotten to the civilian members.
We're just voting on whether equal or higher. We're putting higher before you right now.
There was a motion for higher, seconded, and so that's what we haven't, that is to be determined, we're going to vote.
A roll call on this, or folks just want to raise hands? Huh? Roll it.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Good clarification on that? That's, so we're saying 3 members. We're voting on one of them. Are we going to vote on the next one and the next one? Just vote on each person?
Yes.
Okay, so this is the voting, this is the one officer of a higher rank. Yes.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Just for clarification, it is only if he's a higher ranking person, it's not the same rank?
Only higher.
Okay. No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Officers team up against.
You retired as a major?
So I'd like to move that I propose a second cop who's of an equal rank.
You second it? All right, Senator Heddleman, go ahead.
We were talking about 3 people
We are, so he's now talking about
A
the second person.
being a
Which-
law enforcement officer.
Correct.
But the original amendment was to have 2
Well,
civilians.
we broke it out. We've been voting
I
on, we're
understand.
going line by line. So we can defeat this and keep moving, or you can adopt it and keep moving, so.
My proposal is that we add another cop on. I'm not saying that we don't have 4 or 5 civilians, I don't care, but I think we need I'm proposing, and I'm also adding on one more cop who's of equal rank.
Again, I just foot stomped once you start building it out, just the availability and the timeliness, but. Senator West.
Could I ask the 2 senators who have experience in law enforcement whether having someone of equal rank on the board would be helpful or not helpful?
So, okay, so I can put this out there real quick. If you look at the way technology has changed in the last 3 to 5 years, just with everything that exists, if you were to look at an officer of higher rank that didn't work on the street with you right now, who had worked there 5 years ago when technology was different, they do not see things the same way through your eyes. So you want, when you're sitting there in that trial board and you're explaining your position, you want to be being judged by somebody that is sitting there and has sat in that same position in the same mindset as you, right? It's all about, when we're talking about this, and we're talking about decisions that happen in a split second. Maybe. So what I was talking about was, I was talking about decisions that happen in a split second, right? So you clearly want that person that is thinking in the same mindset with you, right? If they had been on the street 5 years ago and then they'd been in the office or in supervision since then, when you become a supervisor, you go to Maryland Police Training Commission, and quite frankly, as a good senator will tell you, you sit there for a couple weeks and they completely retrain the way that you think, right? Because at that point in time, when you leave the rank of just being a patrol officer, the whole scenario changes when we talk about liability. Liability on the police department is much higher when you have a person of higher rank than when you just have a person here. So they are no longer looking at this person that's sitting there as the person that you're hoping to look at it through your eyes. They now, because of that higher rank, are looking at it with a different liability standard. So they can't look at it from the officer. I think this is critically important if we want to say that these people are innocent until proven guilty. If we want to give them the benefit of the doubt and we want to have a trial board that really makes sense, I think it's critical that they have someone of their same rank.
Well, my original proposal was equal or higher rank. I mean, I do understand having someone who understands that. Again, in order for us to get something through, I mean, look, we came from 5 members to 0 members. And so my compromise was in the middle, and with the original proposal, equal rank or greater. So I do not disagree. I agree, but I think,
Got a motion that's been seconded, but go ahead, Senator Huff.
I like this because it was what I got to earlier about having somebody who's enlisted, or like think of the military, having a grunt versus having all the officers, guys that all went to college, guys that are all management versus the working people. So it's like, it's almost, in some ways they say, but it's true, it's almost like a class thing. To have somebody of their same rank that knows what's going on, that is the same, essentially class as them. I mean, it's management versus employees. So it's that basically have another employee there versus with management. Otherwise, it's just all management against you. I mean, we can get into, if this gets accepted, people want a majority civilian, Get out a third civilian on.
So let's roll it. So what the amendment is to add another member, and that member should be a sworn law enforcement officer of equal rank. Is that right? Okay.
Vice Chair Waldstraker,
No.
Senator Lee,
No.
Senator Castley,
Yes.
Senator Heddleman,
No.
Senator West,
Yes.
Senator Sidnor,
No.
Senator Jackson,
No.
Senator Bailey,
Yes.
Senator Carter,
No.
Senator Huff,
Yes.
Chairman Smith.
No.
All right, let's take the next two then. So next with the next three civilians. Try to just go to the next line down.
So it would be,
So that would be to
Two
strike.
civilians.
Yeah, sorry. So, but I want to. So then we want to do is the amendment would be to strike if authorized. That. Or, or does it make more sense just to go to the three civilians?
so the amendment, sounds like is to strike the provisions relating to local laws or ordinance that authorize civilian individuals to participate in the boards, and to instead mandate that each board have two civilians who've received the training administered by MPTSC.
Direction at the moment. I'm sorry. How many counties in the state currently do not have civilians serving on these boards?
So, as far as I'm aware, Senator West, only Baltimore City and Montgomery County have civilians that participate in this way.
So the other 21 counties don't want them? Because they have the right to have them.
They just haven't done it yet.
They have the right under current law to do it, they haven't done it.
Yeah, it's been since 2016, I think, right? Is that right, Senator Castley?
They have the right to do it, and the challenge that my county has had is civilians aren't interested in this. Who wants to spend 2 days out of their life on an issue where the sheriff says that this guy repeatedly uses the wrong radio calls and is derelict on his radio? That's really exciting stuff, and you're going to spend a few days of your life watching that. Or this person is habitually late. It's just dynamic stuff. So most of your stuff is not, did Officer Jones, rape somebody or something? Of course, it never gets to that, because this is all boring stuff, because this is administrative stuff. That's why it's before a trial board and not before a criminal court. I mean, it's pretty mundane, boring stuff that most people have no interest in. So I'm just wondering, once we adopt this, two civilians, what if you can't get them? Because they're not paid, they're just two civilian volunteers, and the chief's trying to run a trial board to get rid of a cop who just isn't a good cop, doesn't do anything too exciting, he's just not doing stuff, so it's a really boring, mundane thing. He can tell officers, be there, be square, you're on the board, be there on Thursday and Friday and sit on the board. Can't say that to civilians. He doesn't have the right to summon them for jury duty, so it's totally would you, mother, please come. So just curious what's going to happen. Otherwise, if you can't, we're saying it has to be two civilians. If he can't get two civilians, cop just sits there and waits. I'll wait till hell freezes over, because you can't discipline me till you can get two civilian volunteers to come in here.
Senator Jackson.
The amendment states that if the civilians aren't available, then two officers are assigned. Right? Jamie?
I was just going to say
the,
that all agencies have both sworn officers and civilians. There's nothing in the language that would negate a civilian member of an agency,
So it
unless we
does.
wanted to change that. Right?
The language does say, I had the same thought, Senator Carter, and the language does say member of the public, so you might want to rephrase the language that's there if you wanted to open it up to civilian members of the law enforcement agency.
I didn't necessarily, I just thought it already was open to that.
This is a very real problem. This is a very real problem. I mean, I've had my sheriff tell me, he wants to have the public involved. He wants that perception. He wants the openness. He wants the public to know, and he's tried to get them on, and he's just says he can never get civilians interested to serve because the stuff isn't glitzy. It's not a juicy murder or rape trial or something that people want to get involved and listen to it. It's boring stuff. It's serious, but it's boring.
Really quickly,
I was just going to say, I like the idea of getting rid of 2 members of the public and just say 2 civilians who received training, because what you could end up happening to fill your need on what you're talking about is basically people who've gone through this training. You're going to basically have people that are maybe essentially like arbitrators that go around and do these, and they can bring them in. You know, there'll be, I don't know, 50 of them, 25 of them in the state. They might have to pay them, but it's probably not a bad idea if you just say civilians and they can bring them in.
We don't want the paid arbitrators coming around. That's why we're in the problem we're in right now, is because we have a group of people going around who get paid for this, and they know what you got to do to get paid.
Well, you just said we're not going to get Joe Schmo off the public to come and do it for
Well,
free.
I think that's why Jamie's suggestion that you can, the sheriff could get public employees. He can get somebody from.
Well,
the
if it
public
just
works.
says 2 civilians instead of members of the public, then
Right, so if we
they
strike.
can pay someone, they can find someone of the public, they can.
He can strike the word public and it's then 2 civilian employees, and then.
Well, no, I just said two civilians, and then they could take employees, they could take the public, they could hire arbitrators.
Civilians. Senator Carter.
probably not necessary to say, but I just wanted to reiterate that one of the goals that we're ostensibly moving toward is having these processes open and transparent, and to ensure that public is allowed to have some participation and some say and some input. So that's why I lean more toward your regular members of the public of the jurisdiction where the police serve, so that they're able to participate in the process, not these professional arbitrators or whatever. And then I was wondering if anybody wanted to entertain that, like some other boards, that people would receive some modicum of compensation for their service. No, it's not a big deal, but we're talking about people not wanting to do it.
Let's get the
Even-
board,
even
let's get
jurors,
this thing
even
established,
jurors,
however it's
since
gonna get
we're making this a jury
established.
trial, even jurors get $15 a day.
Let's go back to the amendment. All right, here we go. Let's just pull back real quick. Let's focus back on the amendment. So go ahead.
So the amendment would be to make it no longer discretionary on the part of the local jurisdiction, and mandate that 2 members of the public who've received training from MPTSC be members of the board.
I want to strike that, make it 2 civilians. That's fine.
Civilians, yeah, that's
So-
fine. That's
So
fine.
2 civilians?
Yeah,
Okay.
2 civilians.
And not have the requirement of the specialized training that's currently under the law now for the civilians that are on the board. I don't.
So let's see, hold on. Let's hear this. Senator Bailey, let's hear that. Let's hear what you have to say on that.
So when we're talking about rules and regulations, right, and policies and procedures, that's what we're really talking about here, is the policies and procedures of the police department. So it is important that the people that are actually, because police are governed much differently than any other any other job, right? The policemen have a different standard. And so the situation is the person that is going to sit on that board should have some semblance of what it is, because if they don't have that training beforehand, it's going to take 2 days to do jury instructions, quite frankly, like you would on a jury, right? To say, well, this matters and this matters. If that's what the whole thing that happened in 2016, and I wasn't here. You were here and might want to talk to this, but the whole thing was, that was the whole thing. Establish something that the public would have a say in it.
So it was interesting because your jury analogy made me think that, and I suspect this is what Jill may say, but that the training may not even be necessary on this, because like when we go out for jury duty, you're not trained. But I want to hear what you have to say, Senator Carter. I know you wanted to get on it. Sorry.
I don't have a whole lot to say on it. Thank you, Mr. Chairman. Just that, this group that insists that we need trial boards insists that we need these many trials like jury of the peers type of thing. And my argument is that we're talking about regular members of the public that should have input in how their police conduct themselves. Then I don't know that they need specialized training like there are many civilian police officers. They can just be members of the public, and they're here to say, hey, look at these facts and make a determination. Like, what is the necessity that they be trained? Like, if they're literate.
Well, I guess we're not checking their voter registration. I'm just joking. But look, this is already established in 1016, HB 1016. The Maryland Police Training and Standards Commission geared up to train civilians to sit on these boards. So this is already established. I don't see any harm of us keeping this in the language that they're trained up. And I think it's up to those local chiefs and sheriffs to make sure that as they publish this or promote this, that they get folks who are interested trained up. But it's already established.
I just think you really got to focus on what is the purpose of this? What are we doing? And the purpose is to get rid of people who are not good police officers. This is technical stuff. This is not just about guilt or innocence. And this isn't a trial to have you put in jail or what. This is to say, are you somebody who should still be a cop? And so it's to say, did you comply with all the rules and regulations? Are you doing policing right? Are you somebody to keep here doing policing right? This is not like you're saying, oh, well, you met the elements of the crime. You were speeding, you were in a car, you were driving, you were going 85. Boom, I don't need to know anything more than that. I don't need to be a mechanic. I don't need to understand anything. You met the elements, you get convicted. This is, are you a good cop? There's so much more to this, and it's not just it's not elements of a crime. It's whether you uphold the values, the capabilities that we would expect of a good law enforcement officer, and to just
All right.
that's why I don't like the trial analogy, because it's not guilty or innocence. It's
Yeah.
much more, because they're recommending
I got
you
it.
get suspended or not.
Here's
and all
the
that.
let's move off the dime on this. So, can you read the amendment one more time?
So the amendment would be to remove the allowance for a local law or ordinance that would put civilians on the trial boards, and just require that there be civilians on the trial boards who had received training from MPTSC, and specifically using the word civilians.
All right. So look, Senator Carter goes ahead and speaks. There's been a motion that's been seconded, but it's open for discussions. Go ahead.
Just a point of clarification, that's not exactly correct. Senator Castley, these these boards are not determining whether someone should be a cop. Actually, they're just determining whether or not they should have a disciplinary finding within their current employment. Like what we know, one of the whole things about policing is that someone could actually be disciplined in one agency or terminated from one agency, but they're still eligible to be a police officer. They can go be someone else. So I don't want to overblow what the responsibility of these members of the board is. They're just there to determine whether or not they're fact finders. They look at the facts that are in dispute and make a recommendation based on what they see. They're not. I don't know that they need to be technically trained, but I'm not going to fall on the sword on it.
Yeah, I just want to say real quick. I mean, it's important if they're disciplining police officers, they actually understand what it takes to be a police officer. They're not just guilty or not. They're citing, this take down their rank, down their pay. How do you take down somebody's rank if you don't even know what the rank structure means? How do you do that? So it's not that involved, but everyone. That was one of the best things I ever did. Went to the Maryland Police Training Commission, did the simulating shooting. I had no idea. So I'm barely comfortable voting for this bill. I'm actually very uncomfortable with 2 civilians and 1 police officer. But if the 2 civilians could just be anybody off the street that doesn't even know the rank structure, the pay, doesn't know anything, how are they going to go in there? It's a trial jury of your peers. We're going completely from a system of police to going to civilian majority and 2 civilians that are untrained. I mean, that's too far.
All right, motion's on the floor. It's been seconded. How's everyone? Everyone good? Or is any vote no? Any no votes? Are there any no votes?
Well, I just want to make sure, I'm a little confused about what exactly we're talking about. We're talking about 2 civilians.
Who have received the motion in front of you is 2 that have police training, have been trained by the Maryland Police Training and Standards Commission. I'm fine with that.
Okay.
I'm a favor on that one, but I don't want to. That's as far as I can go on
Okay.
that.
All right. Yeah, I'm fine with that.
So right now we've got one law enforcement officer of higher rank, 2 civilians comprise this board. Let's keep moving down. We've struck the language, if authorized by a local ordinance.
Well, there's the, in number 2, or item 2, the chief shall appoint 1 member of the hearing board as chair of the hearing board.
I don't know what that means. One member's chair, like 1 member is responsible. That's the administrative piece. Is that the administration of the proceedings? What role, Senator Jackson, does that person play? To be the chair.
The chair.
Well, in that case, I'm really confused then.
Yeah. Nice job.
He's running the hearing, or she, excuse me.
The body appoint their own chair.
Oh, they don't vote. That's enough. This democracy. Come on now.
Does the chief have to appoint, or can the body appoint their own chair? For example, would we rather have President Ferguson tell us we're a chair, or would we rather elect our own chair? Just
I
saying.
would rather have President Ferguson tell me you're my chair. How dare you? How dare you, man?
That's the end of this conversation. All right. So this seems to be pretty procedural, not a big deal. Is everyone okay?
Yes.
Okay. All right, let's keep going.
And, excuse me, each member appointed under this section shall have an equal vote in matters before the hearing board. Going forward, I think the rest of the language being amended is technical and conforming. Changes hearing officer to hearing board. There's the language change that was already adopted by the committee on, so this language actually is a little bit different than what was adopted by the committee for subpoenas. So that's not relevant to the discussion.
We just, huh? I'm just saying, this is simpler language. A subpoena issued under this subsection shall be in accordance with the Maryland rules. It's so nice, I mean. Yeah, it's just so simple. I mean, what, the other's so convoluted. I'm just short and sweet. It's everybody. If you want the other stuff, that's fine. I just find it nice and. I'm just saying this language on subpoenas on the back side of page 10 is nice and simple. Just issue a subpoena under the Maryland rules. But
That's the motion.
okay.
Oh, you want to do that? I mean, it'll be, go ahead, Jamie, comment on that, but it means the same thing.
Yeah, it's what I usually see in that. I mean, that whole section, 2, 3, 4. It's just.
Actually, Kathleen and I agreed on this earlier this session. Remember when the other bill?
We're like,
Yeah.
why do we need to spell this out when it's already the law, right?
It's already law, yeah. So just in accordance with the Maryland rules and you're done.
So, go ahead, Jamie, comment, and then I have no problem. It makes no substantive difference if we're right on this. Are we
So I
right?
guess, would the motion be to undo the adoption of the previous amendment on the subpoena language and adopt this language instead?
And adopt the language that's in paragraphs 2, 3, and, well, actually, it's 1, 2, 3, and 4 under D.
I'm okay with that. But it's the committee's issue now, because we already adopted the amendment, so it doesn't matter what I'm okay with.
Third, this committee wipes out the other one. It's totally technical.
Yes.
What? We are. This amendment's done, and then we go on the bill, right? Trying.
Yes.
We're good. Is it Nate? Ask if anybody opposed that bill, and we can move on next week.
Yes. Yes, that's what he's saying. So we don't need to spell
Can we get a thumbs up on that motion? Because Jill said she's fine with it. Huh?
All right, put the amendment.
Move the bill. We're done.
Right, so let me walk through the enforcement piece of that then.
So Jill and Bob, listen to this because this is on your amendment.
So there's a similar piece in the context of investigations that would need to be changed to be the same. But this says the chief or hearing board may issue a subpoena for the attendance of a witness to testify for the production of records. For a hearing under this section, a subpoena issued under this subsection shall be served in accordance with the Maryland rules. In order for a subpoena to be issued under this subsection, the chief or hearing board shall make a finding that the subpoena is necessary or relevant to making a determination on a contested issue of fact in the hearing. If a person fails to comply with the subpoena issued under this subsection, on petition to a circuit court of competent jurisdiction, the circuit court may compel compliance with the subpoena. No, I don't think so. I mean, the court still has authority to.
Well, if there's a guarantee that there's like literally no substantive change to this.
Right.
If it is, Jamie will read the whole thing and vote.
Okay. So is there a motion that it's been seconded? All right. So is everyone okay? All right. Just All right. So Senator Jackson, you have another amendment that we will consider. Senator Carter, you don't have any more amendments, do you? We're all done with you? Okay. Let's get this Jackson amendment.
Are you still working off of the same amendment, Senator?
No, sir. No, it's the, it's 6035271.
Well, actually, I guess there was, I don't know if the language is the same.
I'm
but
sorry.
In that
I was
section,
reading the wrong one.
there was a change from Senator Carter's bill. So the board, with your amendment, actually not only prepares a written proposed finding of fact, but also recommends disciplinary action, if any, to be taken against the law enforcement officer. So that's on the amendment that we were just on. That's page 12 of the reprint.
The recommendation is not binding, then you want them to make the recommendation.
Yes.
You want that.
Yes, a non-binding recommendation, so. Just as a sidebar real quick, you turn your mic off. All right, council's going to explain this amendment to the group one more time.
So on page 12, the role of the hearing board changes a little bit because of the amendment. So they're required to prepare findings of fact. So if you look at line 19, after a hearing is concluded, the hearing board shall prepare written proposed findings of fact and recommend disciplinary action, if any, to be taken against the law enforcement officer. Actually, the proposed, I just want to flag this, the proposed finding of fact is actually a typo. Right, so as it's amended in the rest of the section, how it would work is the findings of fact would be binding, but the recommendation would be optional.
All right, Jill,
Yes.
can you guys, let's get rolling back on this. Jill, go ahead and speak on the amendment.
I'm a little confused about the amendment, to be honest with you. Is it exactly as it's on this page? Hearing, so you, the hearing officer, am I relying on the hearing board?
Change was on line 19. It says shall, Roman numeral 1, prepare written proposed, and we struck proposed. That shouldn't be there. Otherwise, it's as it's written.
Review the findings and any disciplinary recommended disciplinary action. Within 60 days after receiving proposed finding of facts under.
Let's give Jill a second here, and then we're going to go to Senator Bailey, and then you have more to say?
No, I don't.
Okay.
I don't know.
Why do you, Senator Bailey, why do you want?
So, okay, so the whole thing that we want to do while we're doing this process is we want to make it accountable, right? I mean, that's the bottom line. We want to make it accountable. A hearing should have the perception that it is accountable and it is fair, and it is fair to everybody, both the public and to the officers. If an officer is found not guilty, we have the civilians on the board, the whole thing. We have the officer is found not guilty. That is the decision. And all of a sudden, right, the civilians that we want in there are there. And then that's over, and the chief walks in and goes, I don't like that ruling. Even though we had all the rules of evidence, you're guilty and you're fired. Why do we even have this process? Right? It should be binding to the decision.
I don't think that's true as written, because I think if the chief is bound by the finding of fact, and the finding of fact is that the person alleged to have committed the act did not do the act, then the chief is bound by that decision. The only place the chief is provided discretion is with the penalty, which kind of meets what Senator Carter is trying to do. So if there is a finding of fact of wrongfulness, and then the board recommends a certain penalty, you're going to get suspended for 1 week, the chief can say, I don't think that's severe enough, we're going to suspend you for 2 weeks. But if there's a finding of, if there's no finding of guilt, I think the chief is bound by that because it's a finding of fact.
I agree. You can't impose a punishment for not doing anything wrong. Right? If the board said you didn't do anything wrong, the chief can't punish you.
Senator West, and then I'll jump in after Senator Jackson.
Thank you.
Senator West.
So I agree with Jeff. If the board finds that there was, by the facts, that there was nothing done wrong, the chief's hands are tied. But if the board finds that there was some infraction and then makes a recommendation, say that a reprimand be placed into the police officer's file, this language here, as I read it, enables the police chief to say, I don't care what they recommend, I'm firing him. And I just don't think that's appropriate. So you vested all this power into the board to consider everything and to make recommendations, and then the police chief just totally ignores the recommendation and has the right to do what he wanted to do in the first place because he doesn't like the policeman.
Proposed findings was intentional. Jamie just mischaracterized it. It was probably a mistake, but it was actually intentional that they be proposed findings that were not binding on the chief, because as it was originally written, it was designed that the onus would be very much on the chief here anyway. So.
But Jill, if the board has heard all the evidence and has listened to the witnesses, what would give the chief the background information to dispute the findings and find something different, since he didn't sit on the here as part of the hearings?
So the way that this, I think, first of all, I think there's a little confusion. Senator Bailey was talking in terms of guilt and innocence. Keep in mind, this isn't a criminal proceeding, it's administrative. But the way that this was initially planned is that there's an investigation, pending the investigation, the outcome of the investigation, the chief looks at everything and he says, hey, this is the decision that I'm going to make. And then the officer says, wait a minute, I contest some of the facts, like, so your decision is wrong, I request this hearing, initially with the hearing officer. It was only on contested facts. It wasn't on, like, litigating the whole thing over again.
Yeah, but you're saying that the chief, once they have the hearing and independent people listen to all the people, the witnesses, and determine what the facts were, the chief now can say, I don't care. Thank you very much for your service, but it's not going to affect my decision. The facts are, here are the facts as I find them, X, and here's the decision I'm going to make, Y, which is totally inconsistent with what the hearing board did. What's it? It looks like he can't hear.
He's bound by the factual findings.
Well, yes, but Jill's saying that he should. Jill's saying he shouldn't have to be bound.
Okay, yeah, I'm sorry.
I mean, there's written findings of facts that were to come out, right? So that's there for the chief, but that's different than what is now being added, apparently, that in addition to the written finding of facts, there would also be a disciplinary recommendation. I don't oppose the recommendation. Somebody here has said that this should be the final thing. I think it was you, Senator West, that the chief should not have any discretion.
That's not the proposal. So like, yeah, there's definitely, this is a non-binding, the proposal is a non-binding recommendation is the proposal.
You're right, that's what it says. I'm wondering why. I mean,
Because you want the chief to have that latitude and ability to make that decision, and if they don't agree, then they have to provide a written response as to why they don't agree.
Here's my point. Doesn't this make the whole thing an exercise in futility? If the chief saw the results of the investigation and say he ought to be fired, and then the hearing occurs after that with 3 independent people who listen to all the evidence and then make findings of fact and recommend that he not be fired, and then the chief comes in and says, I don't care what they said, he's getting fired. Why have we gone through the exercise of a hearing? Because it makes no difference.
Senator Huff and then Senator Cassidy.
I just want to second exactly that, because I'm sitting here thinking we're doing all this work. The officer showed up late 3 times, or showed up late twice to work. And the chief's like, I don't like this guy, fire him. So he goes to this board, and the board goes, nah, just garnish his pay for a week. And it goes up, finding fact, yeah, he was late twice. And then the chief just goes, like I said in the beginning, you're fired. So it's like, we created this board that just makes like it's like a recommendation board now. Like it's this process to make a recommendation, but it's what legally? Maybe Bob, you can explain to me why you're favored. What does it get you? Do you think you can go to circuit court now and like?
No, the chief is responsible for the morale and welfare, the discipline. Okay, all right. Okay.
Not what the chief. I know what the chief wants, and I understand the chief discipline, chain of command. I understand all that, but I'm actually struggling. If you are a rank and file officers, why do they want this? Because it gives you what legally? That you can go to circuit court after this and say a board said this but that, and it was arbitrary what the chief did to me? Is that the idea? Like, what does a rank and file officer get out of this?
So
Because I'm looking at it like Chris is saying, we went through all this stuff, and it's like I don't know what they're actually getting out of this.
So I agree with you that because we've removed the other police officer of equal rank from the board, then that really changes the dynamics, because now the police officer is saying, okay, I'm going before a senior officer who's favorable to the chief, because that's why the chief put him on here, and 2 civilians who don't know how to do my job and may not like me anyway. So that's really changed the dynamics of that board. But that's what we decided to do. So now you have a board, but they're making findings of fact. The reason that the chief is not bound by their recommendation is because the chief is the person who's responsible for the discipline of this department. And he has to, or she has to decide what is totally intolerable. And what you or I may feel is, hey, give the guy a break. A chief may say, you know what, I got problems in this department. I got some discipline problems, and you're fired.
The point of creating this whole system for the rank and file officer, what does he get? We're creating a system for fairness and for rank and file officer. I just want to understand.
Yeah. Well, the idea is that he's supposed to be getting a hearing by folks who are other than the chief, somebody who's going to look at this thing other than the chief and say, here's how we see the facts. But yeah,
I guess this is only useful in cases where they feel they did not do the infraction. I guess that's it. That's the only time that this would be of any use, is if they feel I was falsely accused of something I didn't do, and then they can go to this board, and then the board says, yeah, they didn't do it.
I mean, you're right, the process is becoming very anti-cop. I'm not disputing that, but
All right.
we lost on those
So,
motions.
all right. So Jamie, just read it one more time, and then we're going to put it up for.
I'm not sure, but I think I agree with you.
I agree as well.
So this is line 19, and I'll just note the typo, but the role of the hearing board would be to, or at the conclusion of the hearing, would prepare written findings of fact and recommend disciplinary action, if any, to be taken against the law enforcement officer. So the findings of fact are final, but the disciplinary action is just a recommendation.
Sort of like a judge and a jury.
Read to us, and and I do understand your point that the chief clearly needs to have some form of latitude. But I do worry about some situations where they could do something that could really be a little haywire. And I was wondering, most agencies already have what's called a disciplinary matrix for penalties. So if it was your second or third time, the matrix would be higher. Is there any thought that we could follow based on the recommendation that they would have to follow some form of a disciplinary matrix? Because I just think, using the example that we talked about being late, right? And then the chief say, no, I want to make an example of this person. I think that's potentially an issue.
All right, excellent. So it's Senator West, last comment, and then.
Amendment as to what he feels about this language. I'd be interested in what Senator Jackson has to say.
As soon as he gets off, we'll do it.
Okay.
Okay, so what's the question?
Senator West, can you repose your question?
Senator Jackson, we're on the bottom of page 12. And what happens when the hearing board is finished and makes recommendations, actually prepares findings of fact, but the language currently says they merely recommend disciplinary action, and then the chief has the right to decide what discipline to impose, which could be the same as recommended by the board or could be entirely different. What do you think of that?
Question. So my amendment says, my original amendment says, Jamie? The original amendment, the amendment says that proposals will go to the chief, and then the chief will do what Senator West said.
Yeah. Yeah.
We'll follow that.
Yeah. Well, but this proposal says that they would have discretion, that the chief would have discretion.
Oh.
The chief has carte blanche to do whatever he wants to do, as I read the language.
Finds it arbitrary and capricious. It can be appealed to the court.
Exactly.
All right.
I don't know.
Go ahead. So just read it one last time, and then we're gonna.
People can look. People can read themselves.
So the hearing board would have final say on the facts in the case, but their recommendation would be discretionary.
Excellent.
Move favorable.
The Carter Cassidy amendment, you know this is bad.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes. Okay. So what else?
Jackson has a final amendment.
A final. Okay. Council's searching for the amendment. Right, he does not have it. Senator Jackson,
Yes.
what's going on?
So, have you been able to find it, Jamie?
I'd find it in my inbox, Senator. I think I'm going to have to follow up with your staff to track it down, or I can reach out to the amendment office if that would be all right.
On this list, it's not on this paper. It's not on here.
No, it was a separate thing. In concept, what it does is it makes the Police Training and Standards Commission a regulatory commission versus just a repository commission. And then so as we're looking for accountability and of incidents within the law enforcement agencies in the state, we would then have a repository, not only a repository, but also a regulatory commission, as we do in most other professions where you have a focal point. That's the gist of the amendment, and I apologize. I had it with me earlier today. And Jamie and I had spoken about this amendment, and so Jamie, if there's anything you could elaborate further on.
Sure, and again, Senator, I'll work to track that down, but essentially it would give the Police Training and Standards Commission broad regulatory authority to adopt regulations to suspend, conditionally suspend or revoke the certification of a police officer, and MPTSC would be required to get copies of all complaints and records of disciplinary proceedings or information about disciplinary proceedings according to regulations that they adopted. So they would be able to look for the cases that they wanted to conduct inquiries into.
Does everyone understand that? No. Okay, so neither do I. Let's do this. The work that we did tonight, is the motion to adopt that onto Jill's bill so that we have one document to work from when we come back. Okay?
Yes.
I see other deletions on his amendment that we didn't even review yet.
I know, so we're not going to entertain those tonight. We don't have time. So I just want to, right now, I just want to make sure that we have a
Okay,
consolidated
so
piece of
we
work.
put that onto Jill's, but then we can still come back and move more of his stuff onto Jill's later.
Correct. Yeah,
Okay.
we're going to entertain whatever the
Okay,
committee has forward.
That's fine. I got you just looking for one document. I'm okay.
We go back and do cleanup, have, So is everyone okay with doing that? Adopting, okay, one consolidated piece of work? Okay, done. All right, so look, we're gonna take, when Senator Jackson gets his amendment and we can have it before us, we'll entertain that. We've got, 7 minutes left, so we're not gonna be able to we're not getting anywhere else tonight, so we'll just call it. And we'll come back in our next session and we'll have everything tidy, one document to work off of, and we'll be very close. We'll wrap it up at the first half of the next voting session. Sure. Yeah, can we do, Senator Jackson, you're available on Monday, right? Okay, you can zoom in. All right, yeah, let's do Monday. You got work on Monday.
Is Monday here?
Yeah, you have work on Monday. Some people have work on Monday.
See y'all Monday evening?
Monday evening? After exec noms? Monday evening?
We used to always vote Monday night sessions.
All right, so let's do Monday at 6. What time is exec noms at? 6?
So,
5 to 6?
Sidnor, Sidnor and I are in trouble with our delegation, but you can speak to the chair and tell him.
I heard police reform is a major issue for Baltimore City. They would love you to be.
So let's do this. We'll come back Monday at 6 p.m. to vote. It's after exec noms.
Priority. I heard your voice.
Say it.
It was to take in Jill's bill that has some stuff on basically punishing people for having car accidents, or not punishing them, but charging them without having a disciplinary proceeding, and that's deleted here. It's easy deletes, but I don't know if you guys, that's all right, we'll just do it on Monday. We'll just do it on Monday. All right.
Everyone's okay with that? You need to, can you get your, go ahead.
That's why we're coming in the evening. That's why we're coming
Yeah.
in the evening. Yep.
All right.
Everyone's good with it.
All right, happy Valentine's Day, everyone. On that note.